Hello and welcome to A Bit Too Much to Think. On August 14th, 2020, the Ninth Circuit Court of Appeals ruled that California's ban on large-capacity magazines, meaning any magazine that holds more than 10 rounds, these are also known as LCMs, they ruled that this law violates the Second Amendment. Now, technically, they didn't independently rule it. They only affirmed what the lower-level District Judge Benitez had ruled, and agreed that banning these LCMs is unconstitutional. But today, I want to discuss why that is, because right now, 8 other states have these types of bans in place. And if one circuit court rules it unconstitutional, especially the Ninth, which is known for being the most left-leaning court, more courts may soon. And if more courts take similar cases for their jurisdiction, this decision will likely go up to the Supreme Court. Therefore, it may affect you as well. So it's probably good to know why this decision was made. Now, I just want to be clear, even though I personally agree with the legal decision that was made, you don't have to. I'm just trying to lay out the arguments they made in support of their decision. I'm doing my best to stay as unbiased as possible. So a bit of background. On March 29th of 2019, Judge Roger Benitez ruled that California Penal Code Section 32310 was unconstitutional. This is the law that bans LCMs. What's fun about this is that immediately after filing this, it suddenly became legal for California gun owners to buy LCMs. And buy they did. Eventually, Judge Benitez put a stay in order, meaning that while the decision is brought to higher courts, the law is no longer struck down and now can be enforced again. But it took about a week for a stay to be put in order. So for 1 week, commonly called Freedom Week, California gun owners bought potentially millions of these LCMs. This was like a libertarian wonderland to gun owners used to the authoritarian power of the California government, especially on gun laws. And to this day, if you live in California and have proof that you bought a magazine during Freedom Week, the California government cannot take it away from you or prosecute you for owning it, despite attempts to do so. The other important bit of background worth talking about is DC versus Heller. This is a Supreme Court case that this decision we are talking about today relies on heavily. So in this case from 2008, the District of Columbia banned handgun possessions by making it a crime to carry an unregistered firearm and then banned registering any handguns. The District of Columbia also allowed the police chief to issue 1-year licenses and required all lawfully owned firearms unloaded and disassembled or made inert by a trigger lock even while it's in your own home. So to prevent mass shootings, every year you would have to renew your license and pay a fee. Kind of like paying your taxes. It's almost as if the government found a way to make money off of mass shootings. So the decision ruled, among many other things, that, quote, the district's total ban on handgun possession in the home amounts to a prohibition on an entire class of arms that Americans overwhelmingly choose for the lawful purpose of self-defense. This is essentially what is known as the simple Heller test. Is the armament commonly used by Americans for lawful purposes? If so, banning that class of arms is unconstitutional. It's commonly used and for lawful purposes. The last important DC versus Heller takeaway is that pistols are, quote, the quintessential self-defense weapon. So, getting to the circuit court decision. The summary of a decision is always good to read for a layman's terms understanding of the decision, so it gives us a good starting point, even if I am going a lot deeper than this. So it says, quote, the Ninth Circuit employs a 2-prong inquiry to determine whether firearm regulations violate the Second Amendment. 1, whether the law burdens conduct protected by the Second Amendment, and 2, if so, what level of scrutiny to apply to the regulation. Now, I will get to what it means by scrutiny, but for now, the first part. Does the law burden conduct protected by the Second Amendment? So, they break up this prong into several parts, and I'll discuss each one. The first part is that magazines are protected arms, and they use precedent from previous cases to prove this, but it's a pretty simple argument. If firearm ownership is a right, which clearly it is, DC versus Heller says it is, I don't think most people disagree with this idea, then the magazines to use the firearm must be as well, and the bullets are too. Without magazines and bullets, the firearm is useless. So part of keeping and bearing arms is keeping and bearing magazines and ammo. The second part of this prong is that LCMs are commonly used and don't constitute unusual arms. They say, quote, "To determine whether an arm is unusual, courts look to an arm's commonality, or whether it is typically possessed by law-abiding citizens for purposes of self-defense." End quote. They then get into the history of arms and correctly point out that arms that could fire more than 10 rounds have been around, quote, "for centuries." This is a really good read to dismiss the stupid argument that the Second Amendment only applies to muskets and front-loading guns because the Founding Fathers didn't know about any repeating arms. They absolutely did. They also discuss in this part what they go over a lot in the background of this decision. The fact that half of all magazines in the US are considered large capacity magazines, meaning they hold more than 10 rounds. Literally, half the magazines are currently illegal under this law. The next part is that LCMs are used a lot in handguns, which I don't think most people unfamiliar with guns are aware of. The decision points out that almost all Glocks and Berettas, the two most common kinds of pistols in the US, come standard with more than 10-round magazines. Other ones mentioned by the decision are the Smith & Wesson M&P 9, which holds 17 rounds, the Ruger SR9, also 17 rounds, and Springfield Arms XD holds 19. Unless you're buying a gun designed for concealed carry and designed to be as small as possible, you probably won't get one without an LCM. Not every gun is James Bond's tiny PPK. Dick joke intended. So, why does this matter? Well, remember that little simple Heller test we talked about earlier? Well, if guns with LCMs are commonly used for lawful purposes, such as home defense, which is exactly what the court finds here, then the law fails the test and is thus unconstitutional. The third part of this prong is that LCM bans are not a common thing protected under common law. Some firearm laws are acceptable or, quote, permissible regulations, end quote, because they've been around for so long, such as, quote, prohibitions on possession by the mentally ill or felons, laws forbidding carriage in sensitive places, and laws that place qualifications on commercial sales of firearms. But an LCM ban is not even close to this level and has no traceable lineage to any founding era or Reconstruction era regulation. They then go into a history of capacity laws, finishing with, quote, "In sum, laws restricting ammunition capacity emerged in 1927, and all but one have since been repealed." The fourth part is really similar. There is no persuasive historical evidence in the record showing LCM possession falls outside the ambit of Second Amendment protection. They sum it up with, quote, "The record before us provides no persuasive historical evidence showing that LCM possession is understood to fall outside the scope of the Second Amendment. As discussed above, the historical record shows that LCM restrictions are modern creations." So really what they do with this prong is they start by showing why LCMs are protected by the Second Amendment, and finish by proving that there's no reason for them not to be protected. So they kind of get both sides. Prong number 1 complete. On to prong number 2. Strict scrutiny is the appropriate standard to apply. You can think of scrutiny like this. The higher the restriction any law places on a right, the more strict the scrutiny you use to determine if it's constitutional or not. Here's a little example. A law that bans playing football in your backyard restricts your freedom quite a bit, and there are several amendments that type of law violates, so you would use the strictest possible scrutiny to determine if it's constitutional. But a law preventing you from making footballs with human skin you bought off the deep web doesn't really violate any constitutional right, so you don't really use very strict scrutiny here. This prong is also broken up into several parts. Part number 1, quote, "California Penal Code, section 32310, strikes at the core right of law-abiding citizens to self-defend by banning LCM possession within the home." Now, because Heller pointed out that one of the core rights within the Second Amendment is the defense of your home, banning LCMs in the home violates the Second Amendment. The district court decision actually has tons of stories of people attempting to defend their home and running out of ammo, and thus not being able to defend their home, where the decision for the circuit court says rights are, quote, at their zenith. Part 2 is that it substantially burdens core Second Amendment rights. The main reason given is that it bans the possession of arms commonly used for self-defense, and self-defense is a fundamental right. Therefore, it restricts unreasonably the right to self-defense. Now, in this part, they really dive deep into a history of self-defense in the US, and they give a really good focus on self-defense for Black Americans, and the fact that a lot of Black Americans have been denied this right in the past, especially post-Civil War in the South, and what a frustrating fight it has been. It also goes into how important the right to self-defense is for all minority communities, for women, for LGBT communities, etc. Quote, we mention these examples to drive home the point that the Second Amendment is not a second-class right, nor is self-defense a dispensation granted at the state's mercy. Holy cow. Is that sentence a well-written one or what? The other aspect listed as to why it limits Second Amendment rights is because the ban is so wide-reaching. Literally, half the magazines in the US are illegal in California, as I've previously stated. And they disprove the reasons here that the state gives that the law is acceptable. The first reason is that people can still defend themselves with a firearm, even if the capacity is restricted. But the court argues that this regulation imposes a substantial burden on the Second Amendment right. Even if it doesn't completely take away that right, it's still too much of a burden. And if there is excessive burden, no matter what the constitutional right, the law that provides the burden is unconstitutional. So a couple examples of this. The one I thought of would be, we could make a law that bans the letter E from ever being used, and people could still talk freely without using the letter E. But that is a significant burden on the First Amendment, so it's unconstitutional. The court gives the example that no court would uphold a ban on extreme art just because people can enjoy paintings by Monet. Even if you don't like it, it's still a right to have. Now, the second argument the state makes is that the Second Amendment poses an inherent danger that other rights do not. Now, I've heard this argument so many times that somehow the Second Amendment is magically different from all the other rights that we have, all the other amendments that we have. And to this point, the court argues that, quote, individual rights often impose at least some risk on public safety. The right to keep and bear arms is not the only constitutional right that has controversial public safety implications. All of the constitutional provisions that impose restrictions on law enforcement and on the prosecution of crimes fall into the same category. So, it's like when a person clearly commits a crime, but the proper due process isn't followed, and that person walks free. That poses a public danger too. Having a criminal in the streets is dangerous, but we don't restrict that law. We respect due process. They also point out that there's no reasoning behind the number 10. You could argue that a 3-bullet capacity is legitimate because an average of 2.2 bullets are used in self-defense situations. They also say, quote, if it is not substantially burdensome to limit magazines to 10 rounds because the average defensive shooter uses fewer bullets, then there is no reason it could not impose a 1 gun per person rule. And this is because in the average defensive shooting situation, the average defensive shooter is going to use just 1 gun. But why would we ever limit it to 1 gun per person? Part 3 really isn't interesting. It just says that other cases from other circuit courts don't really apply. Part 4 points out that a previous case, Fiac versus the city of Sunnyvale, does not limit them to intermediate scrutiny instead of strict scrutiny. Basically, the circuit court held that the district court in that specific case did not abuse its discretion by using only intermediate. They weren't setting a precedent for all similar cases. So, that's prong 2. Now you'd think the argument is done, but the court is not nearly done finishing off this law. They bring up a new topic, saying that the law banning LCMs does not hold up to strict scrutiny review because even though the state interest is compelling, the law is not narrowly tailored enough. In other words, as stated before, this law is way too wide-sweeping. The law is not, quote, the least restrictive means of achieving the compelling interests, end quote. This does get a little bit into how constitutional interpretation is done, but basically, whenever you're trying to do something that would restrict a right, you have to use a narrowly tailored law, and that has to be the least restrictive means of achieving your compelling interest. Then it's legitimate. But if it's not the least restrictive means, then it fails. Now, the very last part they discuss before the conclusion is that intermediate scrutiny, the very next level down below strict scrutiny, does not pass this law anyway. So even if you tried to apply intermediate and not strict, it still fails. Part 1, they say, is because intermediate scrutiny is still, quote, a demanding test. You still need a narrowly tailored law, which this law has already been established several times to clearly not be. Part 2 deals with the fact that intermediate scrutiny is still pretty wishy-washy when it comes to Second Amendment cases at the appellate court level. The Ninth Circuit Court has varied what intermediate scrutiny means, with different levels of seriousness, different applications. There really is no set precedent, so it could be applied in a very demanding nature. Point 3 points out that some uses of intermediate scrutiny are really weak, and pretty much amount to the lowest level of scrutiny, known as rational basis. Now, this directly violates the Heller decision. Specifically, they cite Note 27. Now, this states that the rational basis test cannot be used, quote, to evaluate the extent to which a legislature may regulate a specific enumerated right, be it the freedom of speech, the guarantee against double jeopardy, the right to counsel, or the right to keep and bear arms. What they're pointing out is, if the brand of intermediate scrutiny is too low, then it directly violates the Supreme Court precedent. Part 4 is a little redundant, but it really drives home this one specific point they kind of dance around. It states that the LCM ban fails to pass constitutional muster under intermediate scrutiny, because the, quote, means chosen to advance those interests are not substantially related to their service, end quote. Really what they're getting at here is they're saying that the means chosen to advance those interests, so banning any magazine that holds more than 10 rounds, it's not really related to what they're trying to do. And that's pretty much the whole thing. So where are we now? As of writing this, there has been a request for an en banc hearing, which the circuit court can either approve or deny with a majority of the 29 judges, other than the senior circuit judges, voting and agreeing to hear the case. If it is approved, a panel of 10 randomly selected judges, plus the chief judge, will rehear the case. Senior circuit judges cannot sit on the panel unless they decided the original case. Now, the reason that California is doing this request is to give more liberal judges on the Ninth Circuit, more anti-gun judges, a second chance to change this decision, because the approving judges for the circuit court decision, which is a panel of 3 judges, the approving ones were a Bush appointee and a Trump appointee. The dissenting one was a Clinton appointee. Now, it's worth noting that Chief Thomas is a Clinton appointee, and in the pool to select the judges, there are 8 Clinton appointees, 3 Bush appointees, 7 Obama appointees, and 10 Trump appointees. I'm not saying that every appointee from a Democrat president will support the LCM ban, and every appointee from a Republican president will oppose it, but that is how things tend to go, even if it's not a hard and fast rule. It's just that presidents tend to appoint judges that agree with their views and their party's views on major issues, including restrictions on firearm ownership. So for now, we will have to wait and see. Thank you very much for listening to this episode of A Bit Too Much to Think. If you liked it, leave a like. If you want to see more, subscribe. And if you have any more thoughts on this subject, please feel free to leave a comment. Try to keep it civil in that comment section, though. Thank you very much for listening, and have a wonderful day.